Right then, let's make a start. Good afternoon, ladies and gentlemen. My name is Alex Troup, and I'm delighted to be introducing you to this second in the series of the St. John's Proprietary Estoppel webinar series that we're running this autumn. I'm going to be talking to you about some potential strategies for defending family farms from proprietary estoppel claims. But before I do, I'm pleased to introduce Brittany Pearce, who's going to be speaking to us about estoppel and equitable easements. A couple of points of housekeeping before we start, if I may. The first is that we have a Q&A button on the bottom of the screen. And if you have any questions at any stage, then please do press that and leave a question. I think we'll probably deal with questions at the end rather than as we go along. So at the end of our both of our talks, we'll have a look at the Q&A button and see what's there. There's also going to be a feedback form, which I understand is going to be sent to you separately. And we'd be most grateful if you could complete that, because it really does help us in running these webinars. If we get some constructive feedback, positive, negative, or indifferent, it doesn't really matter. We'd very much welcome it. So without further ado, I'm going to hand you over to Brittany. Brittany, all yours.
Thanks very much, Alex. So I'm going to be looking at the equitable rights to easements. I think we're all fairly well accustomed to the well-trodden path that is legal easements, but the question of an equitable right to easements doesn't come up very often. So I'm going to be looking at their creation, the limits of proprietary estoppel, and the protection of easements that are created by equity. So at the end of the day, we're still discussing easements. The equitable side of things comes into play chiefly when we're looking at whether or not it's been created and whether or not it's been protected in circumstances where you then have people purchasing land. Now, I've listed there the main ways in which an equitable right to an easement might arise. So the first bullet point, most people will be familiar with the fact that where you have an express grant, you've got to complete it through registration. And until it's registered, it only operates at equity. And at the bottom there, you might have been familiar with cases in which there's an agreement to grant, which perhaps hasn't been executed. Quite often you'll get courts enforcing the bargain between the parties, but then we'll come on later to consider what happens when you end up with successors in title. But most of this talk, I'm going to be looking at how proprietary estoppel plays into easements. Now, those are the basic elements that I think most people will be familiar with. So you've got a servient tenement owner, the owner of the burdened land, allowing the dominant tenement owner, the owner of the benefiting land, to believe that he's going to have some benefit over this burdened land. So for instance, a right of way. Your dominant tenement owner acts to his detriment in reliance on this belief and to the knowledge of the servient tenement owner, who then seeks to take unconscionable advantage by denying the right or benefit. So to start with the absolute obvious, you have got to establish all of those elements. Now, that being said, we're going to come on to look at a couple of cases where the courts have adopted something of a flexible approach that might give you an idea of how courts are approaching the question now. When you're coming up with a case like this, as far as sources go, you're probably going to be looking at Snell's equity for most of your questions about proprietary estoppel. Gale on easements has a good part in it about equitable rights to easements, but it's pretty brief and it won't necessarily get you into the in-depth mechanics of proprietary estoppel. Now, if you get so far as to establish proprietary estoppel, it doesn't follow that you automatically get an easement. So again, to start with the obvious, we're in the realm of the court's equitable jurisdiction. The court has got a lot of flexibility when it comes to crafting relief. And it also means that the court is going to be looking at possibly equitable defences, such as lashes, if those points are raised, or the various equitable maxims that might be raised. There's a large range of options that the court can come up with when crafting its relief. You might end up with a declaration that you have a specific right. You might obtain negative relief, preventing a defendant from taking some intimated action. So, for instance, by blocking up a right of way or severing service media. You might get positive relief. The court might order a party to grant an easement, or it might order damages, or both. There's a Court of Appeal case from 2016 known as Davies and Davies that's quite well known. And what that absolutely hammers home is that proportionality is king in these disputes. So when you're having a look at this as to what the prospects might be and what the range of relief might be considered by the court, it's worth being alive to sort of questions: is there a lesser remedy that is adequate to satisfy the equity? How clear are the representations that are being relied on? How substantial is the detriment? Are there countervailing benefits that need to be taken into account? What is the conduct like on both sides? So why has this become a dispute? Because all of those points are likely to be considered by the court when it's coming on to the question of remedy. Now, we're going to look at a couple of the cases because this quite well illustrates where the courts are willing to go with proprietary estoppel. Starting off with Ward and Kirkland. Now, the dispute that we're looking at was just one of a number of disputes between these warring neighbouring parties. The claimant was doing works on his property, needed to drain bathwater through the neighbouring farmyard. The defendant was a tenant of the farm at the time. Quite correctly, the claimant didn't think that he needed their permission, but sought it anyway because he was being neighbourly. The defendant was fairly ambivalent, referred the claimant to the freehold owner. There's a bit of ecclesiastical law in there that we can gloss over because the freehold owner was connected to the church, but ultimately, for our purposes, he went to the rector who was in charge, and the rector gave evidence to the effect that he didn't know he was granting a right, but his words were to the effect of, "I don't see why you shouldn't." And he was quite happy that the bathwater drainage was going to be installed. But that was done, but at the same time, the claimant installed effluent drainage alongside. Now, he didn't seek any additional permissions because based on the conversation he'd had, he simply didn't think there was going to be an issue. This was all done in about 1955. The defendant subsequently bought the farm, relations broke down, a claim was issued in 1962, and ultimately it came on for trial quite some time later. The defendant didn't help themselves at trial, so the defendant denied being a tenant of the farm, denied that permission was sought, denied that permission was given, all of these being points that went soundly against them. Now, as far as was the bathwater drainage a license that could be revoked, which is what the defendant was trying to do, or could it remain in place by virtue of estoppel? So the main argument focused on the lack of discussion about term. There was no discussion between the claimant and the rector as to how long the pipes could stay in place. The court held that the absence of discussions, together with the fact that expense was incurred in installing the bathwater drainage and the very nature of the works was indicative of this being a long-term plan, led to a reasonable expectation being generated that the right would be indefinite. And so there was an equitable right to keep the pipes in position. As far as the effluent drainage was concerned, that was a trespass. And that goes to show how tightly controlled proprietary estoppel can be. Because it wasn't something that was discussed. And even though if it had been discussed, it would quite likely have been accepted, that doesn't matter. There weren't the representations concerning the effluent. As it was a trivial trespass. The court forms the view the defendant was plainly just being bitter, and that was their motivation. The pipes were allowed to remain and nominal damages were awarded. So what it goes to show is that the discussion you're relying on doesn't need to be particularly extensive. But of course, in that case, it's helpful to bear in mind that the rector who gave permission willingly accepted granting permission. So this wasn't a point that was in dispute for the court to determine. Now, looking at the case of Crabbe and Arran District Council, I won't spend very long on this one because once you know the facts, it's a pretty obvious result. Essentially, the claimant had to pass over the defendant's land to reach the highway, had a right of way to do so, but wanted to divide up his plots and create a second access way for one of the plots. It was agreed, and ultimately, before one of the plots could be sold, the defendant blocked up the access, leaving it landlocked. Pretty unsurprisingly, Court of Appeal said minimum relief needed to do justice was an easement. So on the facts, it's fairly obvious how they get there. The reason I mention it is because their second action was then brought that also went up to the Court of Appeal. And in the second action, the claimant sought damages connected to the impact of the first dispute on the value of this plot of land. And the Court of Appeal said, essentially, that's all very nice. You probably could have got an award, but you needed to bring it with the first claim. So that's a strong reminder of dealing with all of your matters at once. There are a couple of cases that also show the limits of proprietary estoppel. So in Joyce, you had a supermarket was being constructed nearby in the early 90s. There was a Section 106 agreement in place, and there were also local concerns about access. So what the defendant local authority decided to do was meet the concerns by constructing a rear access road that ran behind the property at the heart of this dispute. Now, the owner at the time was the claimant's predecessor in title. He requested some land be transferred to him by the defendant local authority so he could build a garage on it and make use of this rear access. The transfer was never actually executed, but no one took a point about that. And the garage was built, driveway was constructed, the rear access road was built, and the Section 106 developer sort of fenced the boundary between the property and the road and installed a gate. The road was used without issue until 2007, when the claimant purchased it. Now, it's worth noting that in this case, the fact that the right-of-way was exercised for a good 12 years or so was deemed to be totally irrelevant. The court wasn't interested in that. Things came to a head because the claimant wanted to develop the land, and that meant the additional residential units were also going to use this right-of-way. The local authority's position was to deny that there was a right-of-way at all, and that it was only prepared to grant a right-of-way to benefit the existing property at a premium of £5,000. Now, at first instance, the claim actually failed, because whilst the encouragement and the detrimental reliance were clear, there was no evidence that the local authority had any knowledge about the detrimental acts. And if we go back to the second bullet point, that there needs to be an act by the dominant tenement owner to his detriment in reliance on the belief and to the knowledge of the servient tenement owner. And the local authority simply wasn't aware of what was done. So the first instance judge said that this meant it failed, and also concluded that all that was expected was a right of access to be offered, and that was on the table. And it wasn't unconscionable that the right of access on offer didn't match the claimant's expectations. Now, on appeal, the Court of Appeal overturned the decision. It was of the view that the first instance court's view on knowledge was too restrictive and at odds to the flexible approach now used by courts. And there was plenty in the evidence to show exactly what the claimant's predecessor in title intended to do, and that was sufficient to meet the knowledge point. It did think that the withdrawal of the right-of-way was unconscionable. And as far as whether or not the right should also benefit any new development, the Court of Appeal agreed that the claimant shouldn't be in any better position than his predecessor in title. There was no evidence that in the early 90s there were ambitions about development that were discussed, and the right was going to be limited to that contemplated between the parties. It was not so wide as to accommodate the additional development, and that wasn't required by equity. And this goes back to the question on remedy as to what is the remedy required that's going to satisfy the equity. So in the end, the claimant ended up with a right of way without a premium, but it only served the existing dwelling. Armstrong and Shepherd is quite an interesting case, again, Court of Appeal decision, because in an oral conversation, you had a claimant saying that he didn't object to a sewer being installed. But at the time of that discussion, he wasn't actually aware that he owned the land. And that's because at the time, the land was mortgaged and the deeds were with his bank. So he came away from the discussion thinking that he'd been consulted as a general owner in the neighbouring vicinity. The defendant came away from the discussion thinking that they'd obtained the consent from the landowner. Sewer was installed. 7 months later, the claimant brought a claim for trespass, seeking damages and seeking for the pipe's removal. Now, the claimant didn't help himself in that he was adamant initially that there'd never been a conversation about the pipe's installation. And the court went against him on that. And he also accepted that there was no actual practical inconvenience in having the sewer on the land. So there was quite a large discussion in the judgment about the effect of the initial acquiescence. And the way it came out was that the fact of acquiescence didn't debar the claim because the claimant was unaware of his legal rights, so no equity could be raised against him. So he was perfectly entitled to pursue this claim now. However, the fact of the initial consent defeated the trespass point. So ultimately, the decision came out that the pipes were entitled to remain, but the defendant couldn't continue to discharge effluent through them, and nominal damages were awarded for the use that had been made thus far. Ultimately, it sort of left the parties in limbo, but it's quite an interesting judgment when it comes to considering whether or not the parties are aware of their rights when they're having these discussions about rights of way or pipes being installed. The final point I'll mention on the limits of proprietary estoppel is where the interplay it has with subject to contract negotiations. Now, it's very hard to set up an estoppel claim against subject to contract negotiations because they expressly reserve the right to withdraw. So it's very unlikely to be unconscionable if a party does withdraw during negotiations. It's not impossible to set up the claim, but it's a high hurdle to overcome. Now, of course, if you can establish an equitable right to an easement, the question then quite often comes on, what happens when we bring third parties, bring successors in title into the mix? Now, the general view is that the benefit inures for the benefit of the dominant tenement, and that generally the equitable right binds purchasers with notice. Now it says, but this is subject to statutory requirements of registration. This isn't a technical caveat. This is quite a big deal to be aware of because the technical requirements can entirely undo any equitable right that has been enjoyed. It's a very dry area and it's a very academic area, but it's something that's worth wrapping your head around. So if we take unregistered land to start with, I'm glossing somewhat over equitable rights that have been created before the 1st of January 1926, because you're very unlikely to come up against those. That being said, if it crops up, pretty much you're looking at Section 2 of the 1925 Law of Property Act. Now, what about those that are created on or after the 1st of January 1926? The question is whether or not they need to be registered in order to be protected. That comes down to whether or not they're a registrable land charge. Now, Section 2 of the Land Charges Act 1972 identifies various classes of registrable land charge. Section 2.5 identifies equitable easements as a Class D3 land charge. And it says that equitable easements are easements, rights or privileges over or affecting land created or arising on or after 1st of January 1926 and being merely an equitable interest. Section 4.6 provides that a Class D3 land charge is going to be void against a purchaser for money's worth of a legal estate unless the land charge is registered before the completion of the purchase. So you would be forgiven for thinking that that was the answer, that if it's not registered, that a purchaser for value takes free. That in fact isn't the case. Along comes the decision of, in part, Master of the Rolls Lord Denning in E.R. Ives' investment against High. In that case, the facts were that Party A had encroached on Party B's land whilst building. The parties met on site. They mutually agreed that no action was going to be taken so long as Party B could have a right of way over Party A's land. This was agreed. Party B used the right of way. Contributions were demanded and made as far as the cost of maintenance were concerned. And the right of way was not registered, nor was it protected by notice. Years later, the servient tenement came up for auction, and in the auction particulars, notice was given of the right of way. So in this case, the court was concerned with the Land Charges Act 1925, but that doesn't make any odds because the wording is the same. The question was, what is the nature of this right of way? And the answer was that it was an equitable right of way arising out of acquiescence or the doctrine of mutual benefit and burden. So was it a Class D3 land charge? Because if it was, it would have been overreached for want of registration. That's the impact of Section 4.6. The court said that it wasn't a Class D3 land charge. The Land Charges Act was said to have no impact where Estoppel was concerned. And Lord Denning appreciated that this severely curtailed the scope of the Class D3 charge, but was of the opinion that this wasn't disturbing. This decision was approved in the Shiloh case. Now that was concerned with rights of re-entry, but it expressly considered the argument and judgment of E.R. Ives and confirmed that a right by Estoppel, whilst very similar in effect to the easement, was nevertheless not registrable under Class D3. So if you have an equitable, say, right of way arising out of Estoppel and unregistered land, it is not going to be overreached for want of registration as a land charge. So it can go on to burden successors in title. Now, what about if you've got an equitable easement of one of the other categories we looked at? So for instance, a specifically enforceable contract to grant a legal easement. Well, the commentaries suggest that they don't come under Class D3 either, because prior to 1926, they wouldn't have taken effect at law. This is definitely something that's worth getting advice on if you end up with a case like this coming across your desk. But generally, the answer is they don't need to be registered. Things don't necessarily get any easier when you come onto registered land. If you are looking at an equitable right that's arisen before the 13th of October 2003, you're looking at the 1925 Act. And if you're looking at a right arising after the 13th of October 2003, you're looking at the 2002 Act. 13th of October 2003 is obviously the magic date when the 2002 Act came into force. So looking at 1925 first, to start with, if it's on the register, then it's protected. But if it's not on the register, then you need to be able to show it's an overriding interest. Now, Section 70 of the Act provides that a registered land, parcel of registered land, is subject to identified overriding interests. At Section 70, subsection 1A, this protects various easements not being equitable easements required to be protected by notice on the register. So the question came up for consideration in Sellsteel. In that case, there was a contract to grant a lease of a garage and an easement of a right-of-way accommodating the garage. Now, that contract hadn't been executed, but the benefiting party had gone into occupation of the garage and was exercising the right-of-way. At the same time, the defendant had leased land which included the land over which there was a right-of-way to a company that wanted to construct a car wash. And essentially, this right-of-way was very much interfering with the car wash's construction. And the question was whether or not his rights would bind the car wash company. The rights weren't protected by notice, and there was no caution or other entry on the register. So unless he could establish he had an overriding interest, the second defendant was going to hold its lease free of that right-of-way. So the first question was whether or not it came under Section 70, subsection 1A. So did that exclude equitable easements not protected by notice? It was open to the court to adopt a broad view a la Lord Denning, which would have had the effect of broadening the scope of that section. The judge didn't think that approach was suitable when it came to registered land, and disliked the notion of land being burdened by undiscoverable equitable easements. So in the judge's view, pretty much all equitable easements needed to be protected by entry on the register unless they could obtain some protection some other way. Now, Rule 258 of the Land Registration Rules 1925 provide that rights appertaining to land or enjoyed with it are overriding interests within Section 70. So in this case, Section 70 sub 1A didn't assist the claimant at all, but the right was determined to be one that was enjoyed with the land. So under Rule 258, it was an overriding interest, and therefore the second defendant's lease was subject to it, notwithstanding the lack of protection. Same point came up for consideration in Sweet and Summer. 2004 High Court case came on the next year in the Court of Appeal. That was concerned with an equitable easement arising out of proprietary estoppel. Now, there are a number of right-of-ways in that case which hadn't been protected. One was being openly exercised at the relevant time. The other wasn't being openly exercised, but was known about. Both of them were deemed to be overriding interests under Rule 258 because they were appertaining to the relevant land. So if you're faced with issues on that front, you're going to be looking, in all likelihood, at Rule 258. As a side note, you're not going to be looking at Section 70 sub 1G, which concerns the rights of those in actual occupation. We're going to come on now to discuss why those cases have generally failed as part of our consideration of the 2002 Act. So the purpose of the Act, as most people know, was to create a register which is an accurate reflection of the title. It didn't do away with interests that combined land absent registration, but it did severely curtail them. So the Law Commission disliked the result in Sellsteel. And to start things off, Section 116 makes it very clear that an equitable easement is capable of binding a successor in title, but also that this is subject to the rules of priority. So it's not enough to establish you've got an equitable easement. You also need to establish, if they're not protected, that they're an overriding interest. Section 29 deals with the rules on priority. Purchaser for value will take free of any unprotected interest. The interest is protected if it's subject to a notice, if it falls within Schedule 3, and the important part of Schedule 3 is it protects the interests of those in actual occupation, or if it's accepted from the effect of registration. So Section 116 doesn't get around Section 29. All roads lead to Section 29. A couple of cases have tried to bring equitable rights of way within the actual occupation exception, and they've failed. So Chowdhury and Yavuz, the Court of Appeal left open whether there might be an argument in the matter of an easement of parking, that there was actual occupation, but it went on in the same paragraph to say this had to be referable to some personal physical activity. But by and large, for something like a right of way, you're going to find it very difficult to make it qualify as an overriding interest. There was quite an interesting decision recently, relatively recently, that came out of Bristol County Court under His Honour Judge Matthews. Shortland and Hill was the case. It's a 2017 case. In that case, there was a legal right of way to the garage. Garage was demolished. Defendant's predecessor in title told the claimant there was a right of way. Claimant brought in Reliance. And as it was, the first question to be determined was, did the legal right of way still exist? And it did. So His Honour Judge Matthews didn't need to consider whether the defendants would have been bound by the representation, but did consider it. And in his view, Section 116 only applies to proprietary estoppel, not common law estoppels. So common law estoppels being estoppels by representation or convention. Now, the 2002 Act, in his view, was not designed to prevent their operation. It's worth being aware of that because it really hammers home that you're going to need to be aware of what type of estoppel you're relying on. I should say that there's still some ambiguity about what's going to happen if you've got a case where the doctrine of benefit and burden might apply. It could be that it's pretty difficult to take free of the equity but continue to enjoy the benefit. So it might be an adoption of some kind of estoppel, but the jury's out on that and we're still waiting for a case there. So without further ado, having overrun a little, I'm going to hand back to Alex.
Brittany, that's very kind. Thank you very much indeed. Right, let me just share my screen. And hopefully you will now see my screen, which says that what I'm going to be talking to you today about, ladies and gentlemen, is protecting the family farm, some strategies for avoiding and defending proprietary estoppel claims against farms. Now, what I've got in mind here is the classic case of a son or daughter who works on their parents' farm for many years at low wages, on the faith, they allege, of a promise by the parents that one day the farm would be theirs, the classic sort of case that we've all come across many, many times. Even though in the House of Lords, in Thorner and Major back in 2009, Lord Walker said that such cases are rare. That manifestly is not the case, certainly in recent times. These kind of cases have become extremely popular amongst the farming community, particularly here in the Southwest. And we're seeing a lot of them in St. John's chambers. But my focus today is not on pursuing such claims, but rather defending such claims. What strategies can you, if you're representing a defendant, employ on behalf of your client to prevent such a claim succeeding or defeating it in order to defeat it at trial? One answer is you have a good day in cross-examination and you can show that no assurance was made or there was no reliance, etc. And I've heard it said many times that such claims ultimately turn on who the judge believes, and that is true to a certain extent. Certainly these cases are highly fact sensitive, but there are also more technical arguments available to defendants, and it's those which I'm going to be looking at today. Now, as a preliminary point, we are, of course, awaiting the Supreme Court's judgment in Guest and Guest, which concerns the question of how the court should decide what the appropriate remedy is in a successful proprietary estoppel claim. It is an extraordinary fact, ladies and gentlemen, that the hearing in Guest was back in December last year, and 11 months on, we're still awaiting judgment. So in light of that, I'm not going to be talking about the issue of remedy today, and indeed, my colleague Joss Knight in the first episode of this webinar series spoke about remedy, which is another reason why I'm not going to be touching on it. Instead, what I'm going to be focusing on are the three key ingredients for a proprietary estoppel claim as identified by Lord Justice Lewison in Davis and Davis, namely, firstly, an assurance of sufficient clarity, secondly, reliance by the claimant on that assurance, and thirdly, detriment to the claimant in consequence of his or her reasonable reliance. I'll then finish up by looking at a couple of recent cases where the son or daughter has gone into partnership with the parents. And I'm going to be looking at whether the existence of the partnership agreement has got any impact on the merits of the claim. So let's start, if we may, by looking at the first key ingredient, which is an assurance of sufficient clarity. The first line of defence which I want to consider here, which is one that's cropped up repeatedly in recent case law, is the argument that even if the parent has said that they intend to leave the farm to the claimant upon their death, that statement was merely a statement of the parent's present intention rather than a promise to leave the farm. And the classic reported case in which this argument succeeded is the case of James and James, which is a decision of our local Chancery judge here in Bristol, His Honour Judge Matthews. James and James was a classic farming proprietary estoppel case where the claimant, a chap called Sam, contended that his late father had promised him a particular parcel of agricultural land. The judge accepted that the father had indeed told Sam on one occasion back in 2004 that he, the father, intended to leave the land in question to Sam on his death. But the judge held that that was a mere statement of the father's then present testamentary intention, rather than a promise which the father intended the son to act upon. And the judge said this: in my judgment, there is a sufficient place in our legal system for a landowner to be able to express a present intention to leave property by will to another person, but without making any promise to do so, such that he or she is not then bound to leave the property, even if that other, misunderstanding what that landowner has done, purports to rely to his or her detriment on a supposed promise. In my opinion, the present case occupies exactly that place. So the question arises, how do you decide in any particular case whether the statement made by the parent is a mere statement of present intention or a promise? Well, the answer is it all depends upon the context. In James and James, the evidence was that the testator was a man who did not easily make promises to give away property. The statement in question was an isolated incident. It was never repeated. And the testator had not mentioned any promise on later occasions when one would have expected him to have mentioned a promise if one had been given. So that was the context in which His Honour Judge Matthews made this finding. But it's clear that a different result may be reached in different contexts. So in the subsequent case of Haberfield and Haberfield, where the parents were found to have made promises to leave a farm to their daughter Lucy, the court rejected the defendant's argument that the promises were merely statements of the parents' present testamentary intentions. The promises in that case had been made repeatedly, and in the context, the court found that they were promises which the parents had intended Lucy to act upon. So this defence didn't work in Haberfield and Haberfield. The defence did, however, work in the more recent case of Horsford and Horsford, decided a couple of years ago, which again is an example of a case where the judge simply didn't buy the argument that the statement's intention were promises intended for the claimant to act upon them. Instead, he considered that they were simply statements of present intention. So you can see we're getting a line of cases where judges reach opposite conclusions, but it all depends upon the context of the particular case. A different strategy is to argue that the parent statement is not sufficiently clear to found an estoppel. Now, the classic example of this, which is not mentioned on my slide, is an old case called Leighton and Martin. The citation for that is 1986, Volume 2, Family Law Reports 226. And that was a case where a lady moved in with the deceased on the faith of a letter he had written to her, in which he promised her, quote, financial security. And she ran a proprietary estoppel claim based on that letter, but that claim failed because Mr. Justice Scott, who is the trial judge, said a representation that financial security would be provided is not a representation that she is to have some equitable or legal interest in any particular asset or assets. And that decision remains good law. Indeed, it was cited with approval by the House of Lords in Thorner as an example of an unspecific promise, which wouldn't be capable of founding a proprietary estoppel claim. But there's an interesting variation on this particular theme, which is where the deceased makes an assurance to the claimant to leave my estate to the claimant. Is an assurance to that effect that the estate will be left to the claimant sufficiently clear to found a proprietary estoppel claim? Well, that question arose in an old case called Re Basham, decided back in 1986, where it was held that the answer is yes, such a representation is sufficiently clear, but that decision was always rather controversial. Indeed, one of the arguments run by the appellants in Thorner and Majors was that Re Basham was wrongly decided, but in the event, the House of Lords said they didn't need to decide the issue one way or another. But the question did arise squarely for decision in the subsequent case of MacDonald and Frost, decided very shortly after Thorner and Major. Now, in MacDonald and Frost, the claimants brought a proprietary estoppel claim based on promises made to them by their parents that they would receive the parents' estate divided equally between them. Is that promise to leave the estate of sufficient clarity to found a proprietary estoppel claim? Well, the judge, Geraldine Andrews, QC, sitting as a Deputy High Court judge, said that the answer was ... maybe. She said this: although the reasoning in Re Basham is difficult to reconcile with the requirement reiterated in Thorner that the property should be sufficiently identified, it is important to bear in mind Lord Neuberger's warnings about approaching cases of this nature practically and sensibly. The assurances must be evaluated in the specific context in which they are given, bearing in mind that members of a family are less likely to be precise and legalistic when discussing such matters than people in a commercial relationship, such as the parties in Yeoman's Row and Cobb. On that approach, it is not impossible to conceive of a situation in which representations by A to B about my estate could be interpreted legitimately as referring to specific identified property because of the context in which they were made. Though in many cases, possibly the majority, such representations or assurances are likely to be regarded as too vague and imprecise to satisfy the test. The precise phraseology used by the person giving the assurance is far less important than what a reasonable person in that specific context would have understood by it. So I think where we get to is this: if a parent's only valuable asset is the farm, then a promise by them to leave my estate may be interpreted as referring to the farm, because that is the only real asset that that phrase could sensibly refer to. But if the farm is only one of a number of valuable assets owned by the parents, a promise to leave my estate may be insufficiently clear, because it may relate to more than just the farm. It all depends, again, on context. A rather different strategy can be adopted where, as is commonly the case, the evidence suggests that, in fact, only one of the parents, typically the father, made the assurance in question without the authority of the other owner of the farm, typically the mother. Now, this argument came to prominence as a result of a case called Fielden and Christie Miller. That was actually a trust case where the land in question was held by 3 trustees on trust for certain other beneficiaries. A representation was made by only one of the trustees, and it was held that this was insufficient to found a proprietary estoppel claim. The rule is that trustees have to act unanimously, and so a proprietary estoppel claim can only arise if the representation in question was either made by all of the trustees, or alternatively was made by one of them, but with the authority of the others. A representation made by just one trustee without the authority of the others was not sufficient, and therefore the claim in that case was struck out. The baton was then picked up by Master Matthews, as he then was, now His Honour Judge Matthews, in the case of Preedy and Dunn. Again, that was a case where the land was held by a number of trustees on trust for certain other beneficiaries. And the claim failed, among other reasons, because the representation was made by only one trustee and had not been made with the authority of the other trustees. Now, the judge in that case emphasised that the case that he was dealing with there was where the trustees and the beneficiaries were different people. But he did raise in the course of his erudite discussion what would happen if the trustees were also the beneficiaries. So take the classic example of where a farm is owned by husband and wife who hold it on trust for themselves in equal shares. If the husband alone makes a representation, the judge said that in that situation, even if he's made the representation without the authority of the wife, the estoppel would be binding on his beneficial share, but it wouldn't be binding on the wife's 1/2 beneficial share because the representation had been made without her knowledge. So that opens the door to a potential argument in these farming proprietary estoppel cases, which is that the representation has only been made by one of the co-owners, and therefore it's only binding if it's established on that co-owner's share and not the other's co-owner's share. And that argument was indeed run in Haberfield, which was a classic farming proprietary estoppel claim by a daughter against the parents' farm. The parents held the farm on trust for themselves as beneficiaries, and they argued that the assurance was made by the father only and was not therefore binding on the mother's share of the farm. Unfortunately for them, that argument failed on the facts because the judge found that actually the assurances were made by both of them, and to the extent that they were made only by the father, the mother knew and authorised them being made on her behalf. But what Haberfield does illustrate is that on the right facts, this argument can succeed, and if so, it would have the effect of restricting the claim to only a share in the farm belonging to whoever made the representations, and the other co-owner or co-owners who weren't involved in making the representations and didn't authorise them, their share would not be affected by the proprietary estoppel. So it's quite a useful argument. Now, the last argument I'd like to look at under this heading, assurances, is that the assurance is qualified or conditional. And the classic example of this kind of argument succeeding is a case called Uglow and Uglow, which involved an unsuccessful proprietary estoppel claim by a nephew called Richard against his late uncle's farm, which was situated in Cornwall. Richard was able to prove on the facts that the uncle had indeed promised to leave the farm to him. But importantly, that promise was made in the context of Richard entering into a farming partnership with the uncle. Now, that farming partnership didn't go well. After a time, relations between Richard and his uncle broke down, and they eventually decided to abandon the partnership, and they entered into a separate agreement under which they would each have separate areas of the farm, and they would farm those separate areas equally. And the uncle gave Richard a protected agricultural tenancy of his part of the farm. When the uncle died, Richard sought to enforce the uncle's promise to leave the farm to him, but his claim failed, essentially because the promise, as the judge found, was conditional upon the farming partnership going well, whereas it had not in fact gone well, and the uncle had treated Richard fairly by giving him a protected agricultural tenancy instead. So it was held that it was not unconscionable in those circumstances for the uncle to resile from his original promise. Now that went to the Court of Appeal, but the Court of Appeal upheld the first instance judgment. And Lord Justice Mummery said this: clearly, some conduct on the part of Richard would make it conscionable for the testator to modify his testamentary plans and assurances. The nature of the assurance must be implicitly qualified in ways that take into account events unforeseen and not expressly catered for in 1976. The scope of the court's inquiry is not limited to what would be unconscionable for the testator to have done in 1976, but should take account of subsequent events affecting the conscience of the testator. And to similar effect, there's a more recent case called Shirt and Shirt, which again involves an unsuccessful proprietary estoppel claim, this time by a son against his father's son, where one of the reasons given by the judge for rejecting the claim was that the alleged promise was conditional upon the claimant proving himself, and the claimant hadn't proved himself, and therefore no proprietary estoppel claim arose. Now, let's move on to the second key ingredient, which is reliance. Now, to succeed in his or her claim, a claimant needs to show a causal link between the assurance on the one hand and the detriment on the other. Now, the authorities suggest that the test isn't a simple but-for test. In other words, the test is not whether the claimant would have incurred the detriment even if the assurance had not been given. Rather, the test appears to be what would have happened if the parents had told the claimant that the assurance had been withdrawn. If the claimant would simply have continued on in the same way in such circumstances, then reliance is not established. What the claimant needs to show is that had the reliance or assurance been withdrawn, they would have altered their behaviour in some way. But the courts have applied this rule with rather differing levels of strictness. So a good example of the strict approach is the James and James case, to which I've already referred. And in that case, His Honour Judge Matthews held that the claimant couldn't establish reliance. The judge said this: a further difficulty with the argument on reliance is that there's no evidence to show that Sam would have done anything different if it had been made clear to him that in due course he would receive Chequers and the haulage business, which he did, but not Pennymore, which he did not. Pennymore, I interpose to say, was the subject matter of the proprietary estoppel claim. There is no evidence that Sam ever thought seriously about going away to make his fortune in some other industry or occupation. So that's quite a defendant-friendly approach. In other words, the claimant has to actually prove on the evidence that he would have gone away and made his fortune elsewhere had the representation or assurance been withdrawn. A rather different approach, though, was taken by the Court of Appeal in the Haberfield case. The Court of Appeal took a rather more relaxed approach. The claim in that case was brought by the daughter, Lucy, successfully against the parents' farm. And Lord Justice Lewison said, in my judgment, it's not possible to recreate an alternative life for Lucy in a world without the assurances. And he went on to quote Lord Walker in Thorner and Major, who said that it's unprofitable to speculate on what might have been. Now, given that those indications are made at Court of Appeal level, it may frankly be rather difficult to show that a claim is fatally flawed merely because the claimant cannot produce specific evidence of what they would have done had the assurance been withdrawn. But certainly it's a potentially profitable line of inquiry to run if you're acting for a defendant in one of these cases. Now, an alternative approach to reliance is to argue that actually any reliance by the claimant wasn't reasonable. I'm not aware of any case in the farming context where this argument has succeeded, but it did succeed in a rather striking case called Murphy and Rayner, decided back in 2011, which was a carer case. And that involved a claimant called Mrs. Murphy, who had essentially misled the gentleman she was caring for by pretending that she had a daughter who had various financial needs. And that led the gentleman to make promises to her, including a promise that he'd leave his very valuable house in Knightsbridge to her. But at trial, the judge accepted that this business about Mrs. Murphy having a daughter called Vina who was in need was actually a deception on her part, and she didn't have a daughter called Vina at all. And the claim failed on this basis, that the reliance was not reasonable in those circumstances. The judge said this: Mrs. Murphy knew that any assurances to her as to any expectations were impeachable on the grounds of her own dishonesty, and that her expectations were always liable to be defeated by the discovery of the true position concerning Vina. From this, it follows that she could not reasonably rely on any assurances made to her. Any reliance by her was at her own risk, the risk of the discovery of her deception. So if there are grounds in any case that you're dealing with on which it could be said that the assurances are impeachable on the grounds of misrepresentation or undue influence or something along those lines, then this is an argument that you might be able to run successfully. Let's quickly look at detriment, because this is the third key ingredient, but I just want to consider one argument here, which is that the claimant has enjoyed countervailing benefits which outweigh any detriment he or she may have suffered. It's well established that the court must weigh detriment against benefits, and it's only if there's a net benefit that the claim will succeed. A defence that the benefits outweigh the detriment succeeded in the case called Horsford and Horsford. The claim in that case was made by Peter against his mother, related to a farm in Cambridgeshire. And the judge said this: however, it should not be said at this stage that I'm not satisfied that Peter suffered any significant net detriment in reliance on any assurance that he would benefit the farm, or indeed his expectation to that effect. He benefited, as his sisters were also intended to, from his parents' generosity and regard for their farm, family, and future. He worked hard and contributed to the same cause. In context, his efforts to that end were and are not to be regarded as detrimental to him. So if you can persuade the judge that the net position is benefit rather than burden, that is potentially, or it will be, a fatal flaw in the claim and will lead to it being dismissed. In the last few minutes available to me, I just want to turn to the partnership cases very quickly. And what I have in mind here is the situation where parents have promised to leave a farm to the claimant on their death, but the parties have then entered subsequently into a partnership agreement which specifies that the farm is a partnership asset, and the partnership agreement contains provisions which set out what's to happen on one partner's retirement or death, typically it being provided that in that situation the remaining partners can buy out the deceased partners or the retiring partner's share. What effect does that have on the proprietary estoppel claim? Well, that question arose in Shirt and Shirt, which I've already referred to. The parents in that case proposed to the son that they should enter into a partnership agreement along these sort of lines, but in the end, the son rejected that proposal. But the judge said, there is no doubt that if this proposal had been accepted, the claim that the son now advances, that is the proprietary estoppel claim, would simply not be open to him, but it was not accepted. So you can see the door opening there to an argument that a partnership agreement, if entered into along these lines, is a complete answer to the proprietary estoppel claim. And indeed, that argument succeeded in Horsford and Horsford. You'll recall that this is the unsuccessful claim by a chap called Peter against his mother, who's called Marion, relating to a farm in Cambridgeshire. And Peter and his mother Marion entered into a written partnership agreement, which gave the remaining partner an option to buy a retiring partner's share. The agreement contained an entire agreement clause, that is to say, a clause specifying that it constituted the whole agreement between the partners and it superseded any previous arrangement between them. Marion retired. Peter duly exercised his option to buy her share, but he also then said, well, actually, I've got a proprietary estoppel claim because she promised me the farm. How did the partnership agreement square with his proprietary estoppel claim? Well, the answer, according to the judge, was that the partnership agreement was fundamentally inconsistent with the proprietary estoppel claim and provided a complete defence to it. The judge said this: in my judgment, a right to apply to the court for a discretionary remedy that might or might not include the transfer of any remaining interest on the part of Marion is completely inconsistent with both the terms of the 2012 partnership agreement and with Peter's exercise of his option to acquire her interest on her retirement. The legal peg which the judge hung this analysis on was contractual estoppel. In other words, Peter, the son, was estopped by virtue of the contract embodied in the partnership agreement from advancing a claim based upon a prior assurance. Now, that all sounds extremely promising for anyone defending one of these cases in that situation, but there is a little sting in the tail, which is a recent case called Morton and Morton, decided earlier this year. On the face of it, the facts were very similar to those in Horsford and Horsford. The son had entered into a partnership agreement with his mother, which gave him an option to buy her share upon her retirement. She retired. He duly exercised that option. He nevertheless ran a proprietary estoppel claim based upon promises made by her prior to the partnership agreement. But in that case, the proprietary estoppel claim succeeded, notwithstanding the existence of the partnership agreement. Now, why was that? Why did the judge feel able to reach a different result to Horsford? Well, there appear to have been 4 reasons, although I have to say, I don't find any of them particularly convincing. Firstly, in Horsford, the partnership agreement had provided that if the son exercised his option, the mother's partnership share was deemed to accrue to his capital account immediately. So in other words, her partnership share vested immediately in him, and the only question was how much money he had to pay her in return for it. In contrast, the judge in Morton pointed out that the partnership agreement didn't contain any deeming vesting clause like that. The contract was therefore still executory and remained to be completed. So that was the first ground on which he distinguished Horsford. Secondly, the judge in Morton said, I can see no reason in principle why, by entering into a new partnership agreement incorporating new rights in the assets assured to him, Simon should be deemed to have given up his right to rely on the assurances. Now that strikes me as rather odd. The answer, it seems to me, is that the reason why Simon is deemed to have given up his rights to rely upon the assurances is that he's entered into a completely new and inconsistent agreement with his mother. But that argument didn't seem to find favour with the judge in Morton. Thirdly, the judge in Morton pointed out that, unlike in Horsford, the partnership agreement in Morton didn't contain an entire agreement clause. And fourthly and finally, the judge in Morton held that the court's power to grant relief is sufficiently wide to include an order varying the rights of a promisor and promisee under a partnership agreement. And that's exactly what the judge proceeded to do. He varied the partnership agreement, giving the son much greater rights than he had originally been given under the terms of that agreement. As I say, that analysis strikes me as rather odd. It's very claimant-friendly. It sits very uneasily with the analysis in Horsford. I don't know whether there's going to be an appeal in the Morton case, but if there is, it'll certainly be worth keeping an eye out for to see how this argument develops at Court of Appeal level. So, ladies and gentlemen, that concludes my talk. I'll stop sharing at this point. And we'll have a quick look at the Q&A button. There's one question. It's this. It's from Rafe Andrews. Thank you, Rafe, for your question. In light of cases like Guest and Davis, is it accurate to describe the lay of the land as unconscionability is the framework that the court bases their judicial discretion in when quantifying the form and extent of the remedy in proprietary estoppel? However, a debate remains open as to whether the doctrine is concerned with rectifying unconscionability as a result of denied expectations or as a result of detrimental reliance. Rafe, I think the answer to that question is going to be supplied to us by the Supreme Court in Guest when we finally get the answer, when we finally get a decision from them. The cases have made it clear that unconscionability is at the heart of the doctrine, but it's not simply enough to say this leads to an unconscionable result, therefore I've got a proprietary estoppel claim. You've got to establish the requisite 3 ingredients that I've been discussing in order to succeed in your claim and be entitled to a remedy of some description or not. But whether the remedy is going to be fashioned by satisfying the expectation or compensating for the detrimental reliance is an open question, and that's exactly the question which the Supreme Court are looking at in Guest. So good question. We don't quite know the answer at the moment. We will be finding out. I think that's the only question, and given that we are 5 minutes over the allotted finish time, I think we'll finish at that point. But on behalf of Brittany and myself, thank you very much for attending our webinar, and we look forward to seeing you at the next and I think final episode of our webinar series in due course. So ladies and gentlemen, have a good afternoon and see you again soon. Thank you very much.
Thank you.